and institutional integrity of this House.
We have details plus the Speaker's other ruling that appears to have paged him against the NDC majority as he rejects their call for him to declare embattled Pandai MP persona non grata.
The statutory 7-day stay therefore remains in force until 1st December 2025. During this period, the High Court's ruling cannot form the basis for the Speaker to instruct the clerk to notify the Electoral Commission that the Pandai seat is vacant.
We have details of that here on Top Story, brought to you always by Telecell Connecting Energies, Holy Insecticide Spray and Coil Enjoyer, Holy Sleep, and also by Shield Pension. Trust into the future with you. Tonight, Minority Leader Alexander Afenyo-Markin set to face disciplinary hearings as Speaker Alban Bagbin refers him to the Privileges Committee for alleged contempt of Parliament. The Minority Leader was cited for contempt by his colleague, the Majority Leader Mahama Ayariga, last week for disregarding a resolution of the House that barred him from attending the ECOWAS Parliament some few months back. First, listen to Mahama Ayariga when he made his case before the Speaker last Tuesday.
I had to intervene and threaten the Speaker of the ECOWAS Parliament that if my delegation returned to Ghana without being sworn in, she will receive a resolution of the Parliament of Ghana directing Ghana to withdraw from ECOWAS itself. It was upon that threat that the Speaker of the ECOWAS Parliament then caved in and swore in four members of our delegation. Mr. Speaker, he has clearly affronted the dignity and engaged in an act that constitutes an affront to the authority of this Parliament. And it is time that the Honorable Afenyo-Markin be put in his proper place. Mr. Speaker, I therefore rise pursuant to the relevant orders to make a complaint of contempt of Parliament and a breach of parliamentary privilege, and to urge you, pursuant to the appropriate orders, to refer the Honorable Afenyo-Markin, Alexander Kwamina, to the Privileges Committee for him to be processed.
Parliamentary Affairs Correspondent Kweku Asante has joined us with more on this particular developing story. Kweku, first, tell us more about this resolution and how the Minority Leader's name was removed from this ECOWAS delegation list in the first place.
Hello, Brace, if you can say that again.
I wanted you to tell us more about this resolution and how the Minority Leader's name was taken out of this list from the ECOWAS delegation.
Well, yes, for years now, Alexander Afenyo-Markin has been one of the very key figures in Ghana's delegation to ECOWAS, so much so that he has risen through the ranks and become the third deputy speaker at ECOWAS. However, since he became leader, in fact, he went to ECOWAS first as an honorary member and then as a deputy majority leader and was HM Sabonsu. He kept that position even when he became leader. And the concerns of some members, especially on the majority side, the NDC side, was that when it comes to ECOWAS delegation and also Pan-African delegations, the leadership of both sides are never part of that. It is actually the deputy leaders who actually join the delegation to ECOWAS. And so Alexander Afenyo-Markin continuously being a member of that delegation, despite now being a leader, was not appropriate. And so Parliament indeed passed the resolution, removing him and replacing him with Patricia PJ. Of course, we know that subsequently Patricia PJ did indicate that she was not interested. Obviously, because of the politics at play, she did not want to be seen as taking over from a position that the leader was still interested in. But despite those concerns, Parliament insisted and passed that resolution, and that resolution has since not been taken back, as it were, and it's taking effect. And so when it was time for the Ghanaian delegation to go to ECOWAS to be sworn in, and according to the majority leader, when they went there, they went to meet Alexander Afenyo-Markin over there, and that created some challenge for the Ghanaian delegation being sworn in, until Ghana actually threatened to withdraw from ECOWAS delegation or from ECOWAS Parliament if the members that Parliament had so approved were not sworn in. Ultimately, those members were sworn in, and the complaint then came. Today, the Speaker of Parliament says, after looking at the facts, he has made a prima facie determination that Alexander Afenyo-Markin's conduct is potentially contemptuous of Parliament, and that will have to be looked into. Listen to the Speaker's determination.
Conduct that conveys the impression that Parliament's decision may be ignored without consequence qualify as an affront to dignity, even if committed outside the presence of the House. Democratic experience across the world teaches that institutions endure not by their formal design alone, but by the conduct of those entrusted with them. The strength of this House, therefore, rests not merely in its constitutional design, but in the consistent respect members accord to its decisions and processes. Honorable members, having reviewed the complaint, the standing orders, and the governing principles, I am satisfied that the matter raised prima facie implicates the dignity and institutional integrity of this House. Pursuant to Order 34.1, I therefore refer the matter, the complaint lodged by the Honourable Member for Boko Central and a Majority Leader to the Committee on Privileges and Immunities for examination, inquiry, investigation, and report to the House.
Well, Kweku, who are the members of this committee, and what are the Speaker's specific directives to them?
So this committee is chaired by Leader Alexander Afenyo-Markin. We know his long drawn, sometimes arguments with Alexander Afenyo-Markin when they meet on the appointment committee and all that. He is the chair. It's a 17-member committee, but because of the very small number of the minority in Parliament, they don't have a very big representation on that. Just about 4 people on there. It is chaired by Leader Alexander Afenyo-Markin. Listen to the Speaker giving out the indication of what exactly the committee should do.
The committee is directed to 1. Ascertain the relevant facts giving rise to the complaint, including the actions taken by the House and by the Honourable Member concerned. 2. Review those actions taken within the framework of our standing orders and the applicable protocols of the ECOWAS Parliament. 3. Determine whether the conduct, if established, constitutes contempt of Parliament or a breach of privilege under Orders 30 and 31A. And 4. Make appropriate recommendations to the House for its consideration. I urge the committee to discharge its mandate with diligence, impartiality, and decorum, ensuring that all parties are given a fair hearing until the committee completes its inquiry and response to the House and reports to the House. I advise honourable members to refrain from public commentary on this matter.
Well, Asante, please stay with me, because another important matter has also been determined on the floor today, where MP for Pandai, Matthew Yindam, has been given a lifeline by Speaker who has ruled that he can remain a member of Parliament up until Monday, December 1. It will be recalled that the majority side insisted that Pandai MP was no longer a member of the House after his election was annulled by Tamale High Court. But Matthew Yindamon also was also blocked from contributing to the budget debate, but delivering a ruling on this issue. Alban Bagbin held that once a notice of appeal had been filed by the MP, the Court of Appeal rules provide that decision is stayed for 7 days. We'll come back to this particular story, so do stay with me. But let me go on to the phone lines now and bring in former Deputy Speaker of Ghana's Parliament, Joseph Osei Usu. I'm grateful to you, sir, for joining us. You've been a leader in the House. You've been a chairman of the Privileged Committee for quite some time. What is your own reading or view on this particular ruling that the Speaker has given in terms of the conduct by the Minority Leader?
Well, I think we can only be guided by the standing order. The standing order says that if a member files a complaint, the Speaker shall refer the complaint to the Privileges Committee to investigate and report. For me, that's all it is. The Majority Leader thinks that the Minority Leader has taken some steps, has not responded to a resolution of the House, and that conduct, in his view, amounts to contempt of Parliament. By our rules, it is for the Speaker to refer the matter to the Privileges Committee to investigate and report. The issue is, I'm wondering, which rule determines which leader goes where, or which member goes to which committee? I was a member of the Parliament for 4 terms. It's for the membership of any committee. It is the side which the member belongs that determines who goes where. When Ambrose Derry was Deputy Minority Leader, he was a member of the Pan-African Parliament. But Honorable Adjoa withdrew from the Pan-African Parliament. Honorable Afenyo-Markin went to the the ECOWAS Parliament. There's no hard and fast rule about who goes where. If there's anybody who has any rule which says that this is how it is said, I'll be glad to know. How leadership of the various sides choose who to go where is actually by practice and by convention. As to whether any side is bound by any conventional practice, such that if they don't do it as such, there will be in contempt of Parliament. I'll be glad to hear how that is determined. But to the best of my knowledge, different leaders often chose which committees they serve. And I really would like to see a demonstration of how it is the House that determines which committee a side presents its members. But there's a committee which sets up the various committees, and each side brings its own nomination. So I'll be surprised to hear.
But in absence of this rule you talk about, we understand there was a resolution in the House to present a certain number of people to the ECOWAS Parliament. Isn't that as powerful or as enforceable as a rule of Parliament?
I'm not aware of any resolution that is equal to the rule of Parliament or standing on. Now, all I'm saying is that the facts leading to the alleged resolution must be investigated. Is it right to insist that you can't go here when that person's side has nominated him to go there? Upon what basis?
So, in view of that, and from what you know, what do you expect the committee will be happening at the committee in the next few days?
Well, I'm looking at the Speaker saying that he has determined the prima facie case. Whether his deputy will have the courage to pay I don't agree with your prima facie case. It's a matter I would like to see how. I think that comment is prejudicial. You only refer the matter to the committee. But when you say you have determined that it's a prima facie case, then you rather have practically directed how the committee should do the work, the basis upon which they do the work. I wonder how a deputy of the Speaker will come to a different conclusion. I think that's a rather prejudicial comment.
So the Speaker shouldn't have made that comment.
I've never heard any Speaker made any that comment in the last 15 years that I was in Parliament. We only refer the matter to the committee. Because whether or not as a prejudicial, it's a matter for the committee to, a conclusion for the committee to come to. It is when the committee is satisfied that upon the evidence before it, the person must give a response. That is what we call prima facie. If you do not give any response, then you are guilty. That is prima facie. The Speaker has not heard any evidence. He has only heard a statement. Can he make a prima facie determination based on a statement? That, in my view, is tricky.
So, I mean, from the foundation you've laid, what could be the possible outcome? Because you've already said that once the Speaker has mentioned prima facie, his deputy may find it difficult disagreeing with him. What could be the possible outcome then?
What it means is that the Honorable Minority Leader is not likely to get justice. He's not likely to get justice. One, I don't think there's any factual basis for referring the matter to the Privileges Committee. I don't think there's ever any rule which says that a leader or a member of Parliament should join this or that. It is the leadership of the side to which the member belongs that determines who goes where. And so I'm surprised to hear that we have decided that you won't go there. Why?
What could be the possible implication if, in fact, it goes against the Minority Leader?
I don't know what punishment can you be given. Standing orders are clear. If they ask you to apologize, they may ask you to. The worst is that if they ask you to apologize and you don't, then you may be suspended for a period. Those are all set up in the standing orders.
I'm grateful to you, sir, for having time for us here on Top Story. Joseph Osei-Wusu is former Deputy Speaker of Parliament. This is still Top Story. While in the House today, the Speaker of Parliament delivered a ruling on the issue involving the Pandai MP Matthew Yundam and the majority, who wanted the Speaker to declare him a persona non grata of the House. But the Speaker says once a notice of appeal had been filed by the MP, the Court of Appeal rules provide the decision is stayed for 7 days. Listen.
The effect of the order, to my understanding, is that the Electoral Commission is to conduct a rerun election within 30 days, implying that the original declaration of Honorable Matthew Yundam as the winner of the parliamentary election is invalid, and the member is no longer a member of Parliament. I, however, bring to the attention of the House the provisions of the Court of Appeal Rules 1997 CI-19 as amended in the Court of Appeal Rules 2020 CI-132, Rule 27(3), and it provides as follows. I quote, "There shall be a stay of execution of the judgment or decision appeal against for a period of 7 days immediately following the giving of notice of the judgment or decision, unquote. In this instance, the ruling of the Tamil High Court was delivered on the 24th of November 2025. The statutory 7-day stay therefore remains in force until 1st December 2025.
Well, Kweku, the Speaker consequently held that Matthew Yundam can continue to hold himself out as MP. Is that it?
According to the Speaker of Parliament, given the facts he has just narrated, Martin Yundam could have legally been on the floor to transact business and point himself out as a member of Parliament, and he did no wrong yesterday when he did show up.
This rule appears to prevent the subject matter of the appeal from being altered or prejudiced while the appeal processes are pending. Therefore, before the initial 7-day statutory stay, the filing of a stay application may yet introduce an additional layer that may prevent changes to the member status within the meaning of Article 97 and 99 of the Constitution. The House's attention is also brought to Article 105 of the 1992 Constitution, which provides that a person who sits or votes in Parliament, and I quote, knowing or having reasonable grounds for knowing, unquote, that he is not entitled to do so commits an offense. It is crucial to emphasize that Article 105 is penal in nature should the member know that he ought not to be in the chamber and he participates in the activities in the chamber. Honorable members, it's therefore too much premature to say that the Honorable Matthew Yundam is disqualified from entering and participating in the proceedings of the House, because this period still falls within the 7 days mandatory stay of execution of the order. Honorable members, this is not a declaratory order. It is an executive order.
Well, let's bring in Rashid Tanko Computer, who is Deputy Director of Elections and IT for the NDC. Tanko, yesterday we spoke on this matter. Now the Speaker has made it clear the MP is still MP until his appeal expires. Your reaction?
Very well. Let me greet. We are satisfied with the ruling of Right Honorable Speaker. We are very much satisfied as a political party. We've been patient since January up to November. 4 days is not a big problem to us. December 1st, from now up to December 1st, just 4 days. So within 4 days, the ban will vacate the House. And then we'll start our business. And so that one, we are not worried at all. We are not worried. We are satisfied with the ruling.
If you say you start your business, what is that? And some people have been wondering, with your super majority, why are you still interested in more seats?
Parliamentary democracy is about representation. It's not about numbers.
Okay.
It's about representation. The people should be represented by the person that they wish to represent them. And they express such wishes through voting. When they voted for a particular candidate, but crooked electoral officers manipulated the process and decided to bring him down to the House. But the law court, they will look at the veracity of your petition as presented. And we presented a very genuine petition with evidence before them, with reliefs. We were seeking 4 reliefs. And it has been upheld.
4 reliefs, which are?
We will mention it. The first one was the 41 that they have issues with, which we showed as evidence. Were also seeking declaration that because they violated Regulation 43 of CI 127, that one should, because of the violation of that, I should nullify all the rest. And we're also seeking that a declaration that he was not validly elected, and therefore it should be nullified. All these rulings are there. If you look at our pleadings and affidavit, we presented all this today to the High Court.
All right. I'm grateful to you. Let me bring in Haruna Mohammed here, Deputy General Secretary of the MPP. Haruna, I mean, how will your party make sure that he still represents his people after this December 1 deadline that he's been given?
Thank you very much, Samuel. I want to first of all put on record, if the Speaker of Parliament is clearly stating and using the Court of Appeal Rule 1997 and reference to CI 19, Regulation 27A, and he's stating the mandatory period of stay of execution, whether requested or unrequested. That is what the Supreme Court has said in the Supreme Court rule, as established in CI 19. If that is what he wants to state, then it is on point of law. But if the Speaker wants to extend that stay of execution to the application of Matthew Nyindam for stay of execution, then the Speaker of Parliament has erred.
How has he erred? I mean, he says the law, once you file, it is active for 7 days until the court either upholds that appeal or throws it away. Where did he err?
I am very clear in my mind and the position of the law. And if you permit me, what the Speaker has read and the ruling, the Speaker was very mindful. That is why I'm situating the Speaker's ruling in that particular circumstance. Whenever there is a ruling per the Supreme Court, the Court of Appeal rule, whenever there is a ruling, there is a 7-day mandatory period for a stay of execution before it is executed, based on the orders of the courts. That's what the Supreme Court, the Court of Appeal rule, as established in the CI. The Speaker quoted Regulation 27(3)(a). He said, for a period of 7 days immediately following the giving of the judgment or decision. So it means that, and it is captioned as stay of execution. The B says that for a period of 7 days immediately following the determination by the court below of an application, and sub-rule 1A, where the application is refused. It means that apart from the mandatory period, the client or the applicant or the appellant has the right to apply for a stay of execution. So once that particular stay of execution is being done by the aggrieved party, after the mandatory period of the 7 days that it elapsed, then the stay of execution application by that particular client will come into force. And that is why the Speaker was mindful and ruling it to the 1st of December, where the mandatory period will end. And mind you, in the same court, we made that particular application, and the court itself fixed it on the 17th of December. So, meaning that the court has not refused it as established in Regulation 27(3)(d). So, there is no any refusal. So, I am telling you that on point of law, the Speaker will be forced to make another ruling after the expiration of the 1st December.
All right. We look forward to that. And if it doesn't, make a ruling that favors your side, what will you do?
For the Speaker, there is only one chamber that it is that passes or that takes decisions on point of law. So it is because the High Court has spoken. That is why the Speaker is basing on it. The Parliament chamber is not meant for decisions of the court. The Chamber of Parliament is not meant for decision of court. It is the court that takes decision on orders. So the order of the court indicated that 17. So before that should be expired, there is nothing that bars Matthew Nyindam from being the Member of Parliament for the good people of Pandai. And again, even if the court rules on the 17th of December, dismissing the application for stay of execution, the same day we can file a stay of execution at the appeal court. And that is what the law is. So nobody should misconstrue the law. the law will continue to be the law. And that is what we want everybody to know.
Harun, I'm grateful to you for joining here. Harun Mohammed is Deputy General Secretary of the NPP. This has been Top Story, brought to you always by Telecel, connecting energies, Holy Insecticide Spray and Coil. Enjoy Holy Sleep, and also by Short Pension Trust, into the future with you. This ends it for Top Story. We'll take some messages, but when we return, we'll take you to CDD for a chat on the Krontini Akwamu lecture, and it's folk themed Galamsey, a country search for a solution in plain sight. And this is the 20th Krontini Akwamu lecture on a theme Galamsey, a country search for a solution in plain sight. The keynote speaker is our own Erastus Asaridonko, multiple award-winning investigative journalist, and you know the work that Erastus has done on this Galamsey file. So do stay and enjoy what Erastus has to present to all of us tonight. Good evening.